Michael Popok, Legal AF, with some breaking news. Jack Smith has refiled the motion to gag Donald Trump and to stop him from claiming, falsely, of course, that the Joe Biden Department of Justice and FBI have attempted to assassinate Donald Trump and his family and Secret Service when they were executing the search warrant back in August 2 years ago at Mar-a-Lago. Donald Trump is going around telling his followers and anybody else that will listen that he was the subject of an attempted assassination plot, that the FBI agents were locked and loaded with itchy trigger fingers, just ready to take Donald Trump out at a moment's notice because he's misinterpreting a standard boilerplate form, so standard and boilerplate that it actually has a very boring name, an FD 888 operations order that goes along with the execution of every search warrant under the auspices of a federal magistrate judge, which limits the use of lethal force when they're executing a search warrant. It doesn't authorize the use of lethal force. It limits the use of lethal force. And Jack Smith, if you may remember, this is a follow-up companion piece to hot takes that we did last week, in which Jack Smith appropriately filed a motion for modifications of conditions for release. Remember that Donald Trump is not just a felon in New York, he's also a criminal defendant in 3 other cases: Georgia, DC election interference, and here in Mar-a-Lago at the espionage case, in which his conditions of release are set by the presiding judge, in this case, Judge Cannon. So after laying out in the motion that was filed just after the Memorial Day weekend, the special counsel's office asked the judge to modify the conditions of release to stop Donald Trump from both polluting the minds of future jurors about that the Department of Justice is rogue and out of control and is trying to take out Secret Service agents and Donald Trump and his family at Mar-a-Lago during the execution of a search warrant, and to put a target on the back of the FBI and to have people think and to subject them to violent rhetoric and worse, and violent attacks by Donald Trump's followers who now believe that the FBI is so out of control, illegal, and rogue that they're going to take out and assassinate Donald Trump. All a lie. Enough is enough. That's not First Amendment. That's not political speech. That's criminality. That is violation of bond conditions, or they should be. And that's what the Department of Justice has told Judge Cannon. Remember, Judge Cannon rejected and denied the motion because, back to Hobgoblin of Little Minds, she found, the Department of Justice violated her rules because they didn't have a required conversation with Donald Trump's lawyers before they filed it, or they had a conversation and it wasn't good enough for the judge. So denied without prejudice. And if you don't have the proper conversation and give me a paragraph at the end of the document about the proper conversation that you had, I will not even look at your motion. I will deny it, and I will sanction you, the Department of Justice. Sanction the Department of Justice. They're trying to bring to the judge's attention that one of her criminal defendants for which she's responsible, and the administration of justice for which she is responsible, and responsible almost alone, is out of control and claiming that he's the subject of an assassination plot. That goes beyond the First Amendment. You don't have a First Amendment right for criminal conduct. You don't have a First Amendment right to defame the Department of Justice and everybody else and undermine the justice system in order for you to raise a couple of shekels from your listeners and followers. In fact, and no less than 3 different occasions on the new motion that was just refiled by it's almost identical, I'll tell you where it's not, from the original motion, the special counsel's office reminded this judge 3 separate times that she has, quote, an independent obligation to protect the integrity of this judicial proceeding. That's on page 1 of their motion. They say it again later on. They say it for the 3rd time on page 7 of their motion, that under 18 U.S.C. 3142C, a law on the books passed by Congress, and that the judge has already acknowledged she has an independent obligation. What does that mean? That means she doesn't even have to wait for one of the parties, in this case, the U.S. government, the United States of America prosecution team, to bring to her attention a violation of her conditions or something that she sees as undermining the justice system, the integrity of the judicial proceedings. She has an independent obligation to protect it, meaning on her own. We call it in the law sua sponte, without having been brought to her attention. She should have called in, is what the Department of Justice is saying. She should have called everybody in on the carpet in her chambers, in her courtroom, and looked Donald Trump's lawyers in the eyes and said, "What are you doing? You're claiming the Department of Justice and the FBI and Joe Biden is trying to assassinate you?" That you cannot do as a condition of your release. It undermines the fair and impartial administration of the criminal justice system. It puts doubt in people's minds, which is, of course, Donald Trump's goals, and it will pollute the future jury pool. She should have been doing that on her own, and that's the reason the Department of Justice says that at least 3 occasions in the brief. Judge, I know you wanted us to, have a certain type of paper and put this in a certain type of envelope, or you were going to reject it, but you shouldn't even had us jump through that hoop, because you should have been calling Donald Trump's actions out, and you should have been doing it on your own, independently, based on your independent obligation to protect the justice system. Because you're not doing it, we now have to refile. And of course, Donald Trump has created a whole nother time-wasting barrier, because they know if they dangle any kind of time waster in front of Judge Cannon, she's going to take it, right? To delay, refile, delay, burn another week, lose another week, get closer to the election, help out Donald Trump. That is what is happening. That will be her legacy. And I have a lot of respect for Southern District of Florida judges. I know a lot of them. I practice there regularly. This is going to be her legacy. This will be in her obituary, how she is handling this case. And if the 11th Circuit reverses her again and reassigns her, so be it. This is the type of conduct that we're looking at. She's going to have to now rule on the merits because it's now been refiled. But what Donald Trump has created as yet another time waster, another barrier, is he said probation department. It's actually probation office. He calls it pretrial services. Pretrial services should be weighing in, Your Honor, and giving you some advice. Because why? Because she can't figure this out on her own. She's not the judge. So they create another little mini judge next to the judge. And the mini judge next to the judge is pretrial services, which is really when you're on probation or there's conditions of release that are being supervised by the pretrial or the probation office. But the pretrial services office, which is also referred to as the probation office, isn't supervising Donald Trump. He's released on his own recognizance. That was Judge Cannon's brilliant stroke. So in the beginning, I saw this footnote 1, that says the government contacted the probation office to ascertain its position on the relief that the government seeks, which is to have a condition of his release mean he can't attack the Department of Justice with lies and put their life in danger and undermine the jury process. But the probation office advised the undersigned, the Department of Justice, that because Trump was released on a bond that does not have a pretrial supervision as a special condition, that office is not supervising him. And it would be outside the scope of their authority to weigh in. But I said, why are they putting that in? Well, now I know why. If you go to the end of the motion, on the last page, because the judge told the parties, particularly the Department of Justice, that they now have to have a separate certificate of conference or conferral that with 200 words or less. I mean, I'm just aghast at what is happening in a beloved court system for me. But here's the Trump position, which had to be reproduced in the single-spaced paragraph by the Department of Justice, per the judge. President Trump opposes the motion. We do not believe that the court or the defense should have to address the significant and complex constitutional issues until pretrial services, they mean probation. Pretrial services has provided its views about whether such a condition is necessary to meet the purposes of the Bail Reform Act and how such a condition would be enforced. We need the expert opinion and guidance of the pretrial services department, the judge who has an independent obligation to administer justice and make sure it's not undermined isn't good enough. This isn't like sentencing where you wait for pretrial services or probation to provide you their recommendation as part of a scheme created by Congress to sentence somebody. We're talking about the conditions of release. That's all within the discretion of the judge without input. We don't bring in expert testimony. We don't bring in pretrial services or probation, especially as noted on footnote 1. when they're not even involved in supervising Donald Trump's release. But that's not what Trump wants. Trump wants the delay. She wants the court to direct pretrial services to provide their input whenever they get around to it, or as they put it, as soon as practicable, meaning hopefully never. And then, we'll get around to arguing on the merits, but we shouldn't have to argue on the merits until the customary 2 weeks goes by for a briefing. Right now we're in middle of June to respond. And then we respectfully request that our opposition deadline to that motion, this motion just filed, which normally would be in 2 weeks, that should actually be pushed off until the court makes the direction of pretrial services and gets the information. I mean, it is the balls that Trump has and his lawyers, but frankly, you have to credit them because they know they have an easy mark in Judge Cannon. If they give her an out, an exit, an outlet pass, she'll take it. If they give her some sort of fig leaf of cover over her decision to delay, she'll take it, and they give it to her. Here, Judge, create a new process that's not required by the Bail Reform Act. Send it off to pretrial services, which isn't supervising Donald Trump at all, and have them weigh in. And then we'll have a hearing. And then a couple of weeks from now, and maybe it'll be July or August, and then he's the Republican nominee, and then we're off and running. Now, the only thing that I differ with the Department of Justice and Special Counsel's Office, and that's usually very little because they're doing well, not in front of this judge, but in general, and Jay Bratt signed this, is that I would have also moved for an emergency briefing schedule to have faster briefing than the 2 weeks. I would have had an emergency motion to shorten time, to shorten up the time here and make this response within 5 days. I think they didn't do it because they're afraid of what Judge Cannon may do. And also, as pointed out by one of my colleagues, the conditions of release are so fundamentally in the ambit of what a judge needs to do on their own, sua sponte, even if they're not required to do, that you shouldn't even have a briefing schedule about it. If this was in front of Judge Chutkan in the DC election interference case, there wouldn't even be a briefing schedule. She would either rule based on the motion, she would call in an evidentiary hearing immediately, and then she would rule, or she would set some sort of immediate briefing schedule. But not Judge Cannon. And this is what happens with young, inexperienced judges and lawyers too. They fall back on the limited amount of training that they have, the limited amount of trial training that this judge had before she took the bench, the limited amount of trials that she handled, especially during COVID, since she took the bench, especially in a sleepy backwater courthouse in Fort Pierce, Florida. Go find it on a map. And she gets very little training. There is a judge academy, like a judge school. It's like 2 weeks. That's all she went to. She did very little work for the Department of Justice when she worked there. She worked in appeals. She didn't try a case. She hasn't handled but, I think 3 other trials. That's all. So she doesn't know what she's doing. And so they always refer back and rely on and fall back on rules. Even if applying them makes no sense, but it gives her something to hold on to and grasp, and something to control the proceeding with. But now she's going to have to make a decision. If she decides to send this off to pretrial services where it doesn't belong, I think Jack Smith needs to take this up to the 11th Circuit, ask them to review this, and give her a direction that she alone as a trial judge needs to make this decision using her independent judgment and independent obligation to protect the criminal justice system. It's amazing to me that I feel like I'm almost teaching Judge Cannon on how to operate in her courtroom. I wish she would watch our videos. I wish she would join patreon.com/legalaf, where she would get our exclusive content at the intersection of law and politics, about the law, about procedure, criminal and civil, state and federal, about how to handle motions like this. Maybe we should open up a judge academy, a judge school, like Hogwarts, but for judges on Legal AF. And on Patreon. I'm going to think about that. I'm going to bring it up with Ben Meiselas. We'll come back to you on that. But in the meantime, we got to report on these things. What's going to happen next? Given Judge Cannon, let me see if I can speculate. She'll set a briefing schedule that's independent from this. She won't strike this with a paperless order like she did the last one. She'll let it sit. She'll set some sort of far out briefing schedule. She'll think it's very interesting about the pretrial probation services process that's being proposed. And she'll want to hear from the Department of Justice separately on that particular issue on a separate briefing. And she wants that in 2 weeks' time or 3 weeks' time. And then once she rules on that, she'll decide whether the substance and the merits of the motion need to be decided at all. And maybe that's sometime. And now we're in the fall. Now we just blew through the entire summer, and now we're looking at October and the November election. That's what's going to happen, some version of it. Whatever it's going to happen, we're going to follow it right here on the MeidasTouch Network, and more importantly for me, on Legal AF every Wednesday and Saturday at 8 p.m. Eastern Time. Right here on this YouTube channel, we're building this network without outside investors, with our bare hands, with your help. Without you, there's nothing. It's me, Ben, Karen Freeman, McNiffalo, and others just talking to each other on some sort of massive Zoom. We don't want to do that. We want to do what we're doing here on this MeidasTouch YouTube channel. Free subscribe, help them get to 3 million. And then go pick up Legal AF on podcast platforms of your choice and on YouTube, Wednesday, Saturday night, 8 p.m. Eastern Time. And then on hot takes like this one. And now you heard about patreon.com/legalaf, where you can get exclusive Patreon content at the entry-level membership amount of about, I don't know, a cup and a half of coffee per month. That's it. Believe me, we'll make it worth your while. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.